Now, judgment has been made in that court case involving former President Jacob Zuma and the fact that he does not want to return to prison. You'll remember that it was ordered that he return to prison after the former National Police Commissioner granted him a medical parole. Obviously, some various stakeholders came on board to say that that medical parole was unlawful and that the president must serve his sentence. Now it's been granted that he will have permission to appeal that decision that was granted by the court, and we've got eNCA's Masego Rahlaga, who's been following those proceedings and joins us now. Masego, as I've just mentioned in my intro, permission has been granted for the president, the former president, to appeal the decision that was previously made by the court. Are we surprised by this decision?
Not really, Rofio. I remember the judge, Elias Matojane, making the judgment today, saying that he's granting them permission for leave to appeal. This is at the Supreme Court of Appeal. He could have actually granted it to them at a lower court. For instance, he could have said that they can argue their matter further to another judge within the High Court. But he granted the leave to appeal to go straight to the Supreme Court of Appeal. So it's not surprising. It doesn't necessarily mean that the judge is saying that some other judge could come to a different conclusion. It could mean that he feels that there is more argument to be had, especially, Rupua, if you were listening to that judgment, or to the arguments rather, during the leave to appeal, particularly when it comes to Section 75 and Section 79 of that act that has to do with correctional services, that Correctional Services Act. There's Section 75 and Section 79. Section 75 gives provision for the Commissioner of Correctional Services to be the one that makes the decision on whether or not to grant parole, whether the parole board agrees with him, the parole advisory board agrees with him or not. It means that he actually can take that decision himself. But there is another part of that Act 79 that actually gives permission for instance, someone higher, like a Minister of Justice and Correctional Services, to also override a decision that was taken on parole. But to go back to your question, Rupua, it's not really surprising. I think a lot of people thought that maybe the judge would say no other judge could come to a different conclusion, but he granted it to go to a higher court. And I think it was so that it can go speedily. Remember, it was heard today after, the applicant, in this case, former President Jacob Zuma, had asked for the appeal to be heard in February. They were saying that they need time to basically prepare themselves. But of course, the judge said that it's urgent, and he decided to hear it today, just a week or so after he made his original judgment. And they were basically saying that this would be unfair on them. But I think all counsel then agreed during the course of today that it is a matter that had to be concluded in terms of urgency.
Yeah, Masego, Advocate Du Plessis, who I think was representing the Helen Suzman Foundation, made reference to that Section 75 and 79. And I think a lot of confusion has come out in terms of the terminology about the fact that he was physically incapacitated, or the fact that he had a progressive illness that kept getting worse. And I think those were one of the things that the judge would have considered when he was making his judgments. He did have about 3 or 4 key points that he mentioned as he was about to announce that judgment.
Well, Rupua, Section 75 and Section 79 actually have to do with the application to be given parole. So in that case, that it was whether or not Arthur Fraser, as the then Commissioner for Correctional Services, had the right to actually, grant parole, because other prisoners would ordinarily go to a parole board, right? And those would be the people who decide whether or not a prisoner is allowed to actually go home. It has to do with medical parole, normal parole, so that wording. But of course, when you speak about his health, his ill health, etc., a lot of the people or a lot of the organization, including your Helen Suzman Foundation, AfriForum, and the Democratic Alliance, who in this case were against Zuma's application, agree that, of course, he is a man who's reaching the age of 80. Of course, it means that he's not well. Of course, it couldn't mean that he is as fit as he was perhaps when he was around 60 years old, etc. They're saying that they agree. They're not saying that he's not sick. But what they have an issue with is an application, or rather the application where the doctors had to fill out forms saying that he in fact is ill and it's terminal, it's irreversible. And they're saying that, well, the doctors later on said that actually his condition has basically gotten better. So it means that he can stay in prison. I think I was interested also, Rapua, in what the Democratic Alliance's counsel said, Ismail Jami. He said that, in prison, President Jacob Zuma was actually afforded good health in terms of, the type of doctors that he had around him, the type of nurses that he had around him. He says now that he's been released, he's just at home with his wife, who doesn't have medical training, and therefore it really does show that his medical condition has not gotten worse and that he's fine and he can go back to prison. So, that was the argument by most of the ones who are opposed to the former president's, decision to appeal this case. They were saying that they wanted the judge to actually dismiss the leave to appeal with cost. And of course, Rufio, I think a lot of people would say that he's almost 80. But you remember that Duplessis, who represents, Max Duplessis, who represents the Helen Suzman Foundation, Rupio, actually said that the fact that the doctors said he got better, but also the fact that the Constitutional Court did already consider the fact that the man is almost 80, that he is ill, and still impose that punishment on him, shows that, he should finish his term. It's not a long term, it's 15 months, and it's not fair that he was released so soon, and they all agree that this is likely because of the position he held before as president.
Yeah, and that was a very interesting and important argument, Masego, and I'm glad you brought it up, where Ismail Jami said that now that he's at home, he is living in suboptimal conditions, given the fact that his wife is not a medical practitioner. But it's an argument that Advocate Dalimpofu and his colleague hung on to quite strongly. They argued that the doctors that gave him that report said that there was no prison that could cater for the former president, and basically what the judge had done was give former President Jacob Zuma a death sentence.
Well, that's correct, and it goes back to the original decision by the High Court in Pretoria, the North Gauteng High Court. Its original decision to say that the former president should go back to jail. Its original decision saying that, now that he's been out for however many weeks, it doesn't mean that those weeks will be minused from his entire sentence. He would have to start from where he left off, right? But, in terms of, the medical parole and normal parole, did he get normal parole? I think this goes back to your very first question as well, Rupua. This is why the judge, I think, decided that perhaps the Supreme Court of Appeal would either be able to assist him in saying that he didn't err in his original judgment, or find a different conclusion. This is an argument that Dalimpofu made, saying that, as well as the Correctional Services Senior Counsel, actually, which was a very strong argument. They said that the judge actually made his decision on whether or not President Jacob Zuma or former President Jacob Zuma is really terminally ill. He made the decision by looking at only the application for, parole. He did not have, for instance, all the documents that the doctors and nurses had throughout the time that he was in prison and even before, because remember, the argument is that he was ill even before. These are one of the things that he said in the papers that he was originally supposed to hand in to the Constitutional Court before the judgment was made. These papers he handed in afterwards, where he said that he was already sick by that time. So their argument was that you did not even consider the fact that there are other medical doctors who could have given you more information. There's other medical papers that you could have asked for as the judge of the North Gauteng High Court to come to this conclusion that he should not be in prison anymore, or that he should. So that was a very important argument, and at some point, actually, Judge Elias Matojane said that it's a sound argument. He actually said that to Advocate Dalimpofu that that argument is sound. So I think those are some of the reasons why he said to them, sure, you can go to the Supreme Court of Appeal and let's see if they come to a different conclusion.